Okay, well, welcome everyone to the annual Saskatchewan Law Review lecture, and hello to everybody who is joining us online. My name is Martin Phillipson, and I'm the Dean here at the College of Law at the University of Saskatchewan, and I'm also the faculty editor of the Saskatchewan Law Review. As we gather here today, we acknowledge we're on Treaty 6 territory in the homeland of the Métis, and we pay our respect to the First Nations and Métis ancestors of this place, and reaffirm our relationship with one another. I'd like to acknowledge some members of the judiciary who have joined us today. Chief Justice Robert Lehrer of the Court of Appeal and Chief Justice Martel Popescu from the Court of Queen's Bench of Saskatchewan. And I would like to thank our guest speaker, the Honourable Justice Malcolm Rowe, for joining us today. It means a great deal to the college that once again able to host a justice from the Supreme Court of Canada, and it's a wonderful opportunity for our students and faculty and others, and we're extremely honoured to host you today. I would now like to introduce the managing editors of the Law Review, who will give the formal introduction, Ala Buzitit, Carla Fast, and Brenna Trefo. Thank you.
I'm short, so I have to move that down. So the Saskatchewan Law Review lecture is a significant annual event in the college. We are really grateful to have hosted several eminent speakers for past lectures. They have included, earlier this year in March, we had Justice Michelle O'Bonsawin of the Supreme Court of Canada. In 2023, we had the Honourable Gerald Morin, former judge on the Provincial Court of Saskatchewan. And in a 2020 virtual lecture, we had the Honourable Justice Rosalie Silberman-Abella, also of the Supreme Court. And we all know why it was virtual. So, the Saskatchewan Law Review is a vehicle for the publication of researched articles and comments authored by practicing and academic members of the legal profession, and also by law students and others interested in analyzing subject matter of concern to lawyers. Law students at the University of Saskatchewan get hands-on experience editing a legal journal when they are selected for the student editorial board of the Saskatchewan Law Review. The editorial board is made up of 18 second and third year students, most of whom are seated, I think, in the first 3 rows of the lecture theater today. Members of the board select and edit articles for publication, set policy, and also must write a paper for possible publication in the review. Students learn about legal publishing through this process and have the opportunity to improve their legal research and writing skills.
Today, we are very pleased to welcome the Honourable Justice Malcolm Rowe from the Supreme Court of Canada. We are delighted that he is here today on the 8th anniversary of his appointment to the Supreme Court. Justice Rowe was born in 1953 in St. John's, Newfoundland and Labrador. He attended Memorial University from 1970 to 1975 and earned a Bachelor of Science and a Bachelor of Arts. He then attended Osgoode Hall Law School, where he earned his LLB. He was called to the bar of Newfoundland and Labrador in 1978 and became a member of the Law Society of Upper Canada in 1986. Justice Rowe first worked as clerk assistant in the House of Assembly of Newfoundland and Labrador, where he served as procedural advisor to the Speaker. In 1980, he joined the Department of External Affairs as a foreign service worker. In 1984, he joined the Ottawa office of Gowling and Henderson, first as an associate and then as a partner. While in private practice, he was part of the legal team that took the dispute over the determination of Canada's maritime boundary around the French islands of Saint-Pierre and Miquelon to international arbitration. He was also intensively involved in international negotiations and litigation concerning high seas overfishing on the Grand Banks of Newfoundland. Specifically, he was involved in negotiation of a new United Nations Convention on High Seas Fisheries, initiatives at the United Nations Food and Agriculture Organization, and extended negotiations with the European Union. In 1992, he was acknowledged with a Queen's Counsel designation. In 1996, he became Clerk of the Executive Council and Secretary to Cabinet in the Government of Newfoundland and Labrador. While in this position, he continued to advise Canada's litigation team in the high seas fisheries case brought by Spain before the International Court of Justice. Also, while head of the public service, he was instrumental in securing a constitutional amendment to replace Newfoundland and Labrador's denominational school system with a public system.
Justice Rowe was appointed to the Newfoundland and Labrador Supreme Court Trial Division in 1999 and was elevated to the Court of Appeal in 2001. Justice Rowe served as a lecturer in public and constitutional law at the University of Ottawa Faculty of Law, as well as chair of the International Law section of the Canadian Bar Association. He published various articles on public and international law and served on the board of directors of the Canadian Superior Court Justices Association. He was chair of the advisory committee on the federal judicial appointments for Newfoundland and Labrador from 2006 to 2012. From 2002 to 2016, he was involved with Action Canada, a youth leadership development program, as an advisor, mentor, and member of the National Selection Committee. He was appointed to the Supreme Court of Canada on October 28, 2016. Welcome, Justice Rowe.
C'est un honneur d'avoir été invité par le doyen Martin Phillipson à prononcer la 24e lecture de la Saskatchewan Law Review. Comme tous mes collègues à la Cour suprême, je suis heureux de rencontrer des étudiants, des académiciens, des avocats et des juristes à travers le pays. My topic today is the wisdom of Brian Dickson. In their book entitled Brian Dickson, A Judge's Journey, Justice Robert Sharp, retired a few years ago from the Ontario Court of Appeal, former Dean of Law at U of T, and Kent Roach, a professor at U of T, insightfully described Chief Justice Dickson's life and his jurisprudence. The book opens as follows, and I quote, Brian Dickson's judicial career spanned 27 years, from his appointment as a trial judge in Manitoba in 1963 to his retirement as Chief Justice of Canada in 1990. He spent 17 years on the Supreme Court of Canada, 6 as the Chief Justice, and retired as Canada's dominant judicial figure. End of quote. What is remarkable is the enduring consequence of Chief Justice Dickson's jurisprudence 34 years after his retirement. His wisdom and his conceptual clarity are key to this continued significance. His jurisprudence on the Charter and on Aboriginal and treaty rights is foundational. It remains important both for direct reference, notably for the Oakes test, and by virtue of its conceptual frameworks that are carried forward often implicitly in case law. Notably, the conceptual framework was laid out in Sparrow. I will discuss 3 foundational cases which Chief Justice, where he wrote. Big M Drug Mart, relating to the scope of charter rights. Oakes, relating to the limitation of rights under Section 1. And Sparrow, as to the nature of Aboriginal rights. The last of these he wrote with Justice Laforêt. These 3 cases, and others, written by Chief Justice Dickson, warrant continued close study. To begin with, Big M Drug Mart, 1985. Big M Drug Mart was charged with opening on Sunday, contrary to the Lord's Day Act. Big M challenged the constitutionality of the act on the basis that it violated freedom of religion. Justice Dickson wrote, the purpose of religious freedom is so, quote, that every individual is free to hold and manifest whatever beliefs and opinions his or her conscience dictates, provided, inter alia, only that such manifestations do not injure his or her neighbors or their parallel rights to hold and maintain and manifest beliefs and opinions of their own." End of quote. Applying this, the court found that the Lord's Day Act violated Section 2A of the Charter, freedom of religion, as it compelled others to observe the Christian Sabbath. The court went on to decide that the violation could not be justified under Section 1, as the purpose of the Act was to compel religious observance. Now, what is the significance of the case? In Big M, Justice Dickson explained that the Charter, being constitutional in nature, is different in nature and status from the Canadian Bill of Rights, which was, of course, simply a federal statute. In light of this, the court overturned one of its precedents, Robertson and Rostani versus the Queen, which had upheld Sunday closing laws under the Canadian Bill of Rights. Hunter and Southam, which had been decided the year before Big M, had established the broad contours of purposive interpretation. Big M built on this to set out the classic statement of the purposive approach to interpreting the Charter. And in my remarks, I will draw extensively on paragraphs 116 and 117 of that decision. The purpose of the Charter is to be ascertained by, quote, reference to the character and larger objects of the Charter itself, to the language chosen to articulate the specific right or freedom, to the historical origins of the concepts enshrined, and, where applicable, to the meaning and purpose of the other specific rights and freedoms with which it is associated within the text of the Charter. End of quote. Let me list these four factors one by one. First, the character and larger objects of the Charter. That is, its nature as a constitutional instrument and its objective to protect and promote a free and democratic society within Canada. Second, the language chosen to articulate the specific right or freedom, that is, the texts. 3, the historical origins of the concepts enshrined, that is, how the Charter was conceived of by those who adopted it, having regard to the principles of the common law and principles incorporated in international instruments to which Canada was a party or for which Canada was supportive, for example, the United Nations Universal Declaration of Human Rights. And then fourth, and again drawing on the wording used by Justice Dickson, where applicable, to the meaning and purpose of the other specific rights and freedoms with which it is associated within the text of the Charter. For example, the fundamental freedoms under Section 2 are to be interpreted having regard to one another. Freedom of religion, freedom of liberty of expression, freedom of association, and the like. And of course, another example of this is the legal rights set out in Sections 7 to 14. One reads them having regard to one another because their purposes are of a similar nature. So those are the four factors which Chief Justice Dickson said inform the scope of a right. He went on, I would note my own view. Note, these four factors relate to the situation at the time of the adoption of the Charter in 1982. But this is not originalism. A purposive approach situates the object and the purpose and the nature of the right by reference to the circumstances in which it is adopted. However, the living tree continues to flourish. What is dynamic and what changes over time are the circumstances in society in which these broad purposes are given effect. And it is in that sense that while the purposes are to be ascertained by reference to factors which were in play at the time of the adoption of the Charter, how that manifests itself in the expression of the right is an ongoing and dynamic process which gives effect to the Viscount Sankey's formulation that the Constitution is a living tree capable of growth and development within its natural limits. The fact that this was an ongoing and dynamic process was made clear in the next paragraph in Big M. It was underlined that the interpretation of the right should be, quote, a generous one rather than a legalistic one. This has been one of the real failings with the Canadian Bill of Rights. It should be one aimed at fulfilling the purpose of the guarantee and securing for individuals the full benefit of the Charter's protection, end of quote. At the same time, Chief Justice Dickson went on to say, it is important, quote, not to overshoot the actual purpose of the right or freedom in question, but rather to remember that the Charter must be placed within its proper linguistic, philosophic, and historical contexts. These words were chosen quite carefully. Let's look at each of these contexts to which Chief Justice Dickson made. Linguistic, we come back to the text. Philosophic, the political and moral philosophy of a liberal democratic society in the post-World War II era. And the historical objects of a constitutional protection as they were then understood, what I would call a sort of the Rawlsian era of rights development. It was somewhat contemporary around that period. There is a clarity, coherence, and consonance to the Big M test for Charter interpretation. It set out the interpretive framework that continues to govern. As to freedom of religion, Big M held that this includes both, quote, the absence of coercion and constraint and the right to manifest beliefs and practices, end of quote. The Charter, quote, safeguards religious minorities from the threat of the tyranny of the majority, such that no one is forced to act in a way contrary to his beliefs or his conscience, end of quote. As well, Big M was the first case to deal conceptually with the justification analysis under Section 1. The first step was to determine, quote, which government objectives are of significant importance to warrant overriding a constitutionally protected right or freedom, end of quote. Then a court must decide, quote, if the means chosen to achieve this interest are reasonable, if the means chosen are reasonable, a form of proportionality test, end of quote. That was what was said in Big M Drug Mart. I'll come back to Section 1 and the proportionality test in a moment. What is the enduring legacy of Big M Drug Mart? First, purposive interpretation. The impact of Big M in shaping Charter jurisprudence cannot be overstated. A search on Can Lee indicates that the Supreme Court has cited Big M in 186 cases. It's a pretty good track record. The purposive approach set out in Big M has structured the interpretation of a wide variety of Charter rights. For example, freedom of expression, 2B in Irwin-Toy in Quebec, mobility rights under Section 6 in the United States of America and Catroni, and Section 7 rights, BC Motor Vehicle Act. And I could give further examples. Second, the test for Section 1. As I said, Big M's articulation of the test for Section 1 laid out concepts that 1 year later in Oakes were combined into the test that we currently utilize. Third, and freedom of religion. The methodology set out in Big M Drug Mart has guided analysis in 2A cases. For example, in Tunaha Nation in British Columbia, the only case in which I wrote with Chief Justice McLaughlin, we stated that while freedom of religion protects the right to believe and to manifest beliefs, it does not protect the object of those beliefs. As the government action that was challenged did not compel anyone to act contrary to their beliefs, it did not infringe freedom of religion. So essentially, a decision which I think was a 2017 decision was based on a close reading of Big M Drug Mart from 1985. It's just one example of the ongoing significance of that decision. I'm going to pass on now to the limitation of charter rights and the Oakes decision, 1986. In Oakes, it was decided that Section 8 of the Narcotics Control Act, as it was called in those days, which set out a reverse onus for possession with intent to traffic, was unconstitutional. Under the impugned provision, an accused would have to prove that their possession was not for the purpose of trafficking. David Oakes, the accused, argued that the law violated the presumption of innocence under Section 11D of the Charter, and that the violation was not justified under Section 1. Chief Justice Dickson wrote that the law did violate 11D, and then he considered Section 1. He found that Section 8 of the Act satisfied the first step of the analysis, that curbing drug trafficking by facilitating the conviction of those engaged in trafficking was a substantial and pressing objective. But the provision did not meet the rational connection requirement. The presumption was held to be over-inclusive and would lead to results that would defy rationality and fairness. It was not a justifiable limit in a free and democratic society. Now, what's the significance of the Oakes decision? It continues to set out the test for justifiable limitations on charter rights. Chief Justice Dickson identified the two functions of Section 1, and it's important to bear both of these in mind. Section 1 guarantees the rights and freedoms set out in the provisions that follow. It's a general statement to that effect. And second, it explicitly states its own justificatory criteria for the limitation of those rights. Chief Justice Dickson held that the onus rests on the party asserting a charter violation to prove that violation. But when that onus is met, the burden shifts to the government if it wishes to seek to justify the infringement as a reasonable limit under Section 1. There is a, quote, stringent standard of justification, end of quote. First, government must show that its objective is pressing and substantial. Then government must show that the means used are demonstrably justified. In doing so, a court weighs collective societal interests against the right of the claimant or the competing rights of other individuals against the right of the claimant. This is formulated in three steps, three components. First, the measure must be rationally connected to the pressing and substantial objective, rational connection. Second, the means should impair the right as little as possible, minimal impairment. And third, there must be a proportionality between the deleterious effects that arise from the limitation of the right and the salutary effects of doing so. The more severe the deleterious effects, the more consequential the salutary effects must be. Often the decision as to whether there is a justification of an infringement under Section 1 turns on this final balancing of deleterious and salutary effects. This tends to be very much a policy-laden exercise. Now, there's an enduring legacy here because Oakes continues to serve as the framework for Section 1 analysis. Over time, this framework, I have to tell you, seems to have become less clear when it relates to legal rights, Section 7 to 14 of the Charter. And I'm going to give you a quote from Constitutional Law by Haag and Wright. I'm quoting from the 2023 version, starting at pages 14-13. Quote, "The key question is whether and how the countervailing charter rights of third parties or other values or societal interests should inform the principles of fundamental justice under Section 7 or the analysis under Section 1. The Supreme Court of Canada has not adopted a consistent approach to this question over the years." Not my words, those of others, but I quote it. That's, of course, a question for another day, but I do note it because while I think the jurisprudence on Section 1 has been consistent and somewhat clear, the interrelationship between the justification exercise under Section 1 and the operation of the internal limits under Section 7 is not clear. However, returning to Oakes, the three-step proportionality test, which is set out therein, has informed adjudication of rights in the United Kingdom, in Israel, in Hong Kong, at least for a while, in Australia, and in South Africa. So this is a great credit. It's a great credit to the court, and it's a great credit to Chief Justice Dickson. I'm going to turn now to the third case, and that one relates to the nature of Aboriginal rights. Sparrow, the Queen and Sparrow, 1990. In 1985, Ronald Sparrow, a member of the Musqueam First Nation, went fishing on the Fraser River. He was charged under the Fisheries Act for using a net that was longer than that which was prescribed in the regulations and that had been put in his license. You may use a net of a certain length, no longer. His net was longer. He was charged accordingly. At trial, he argued that the license requirements were inconsistent with his rights that were protected by 35(1) of the Constitution Act 1982. Chief Justice Dickson and Justice Laforêt described the rights protected under Section 35(1). And again, it's a classic statement. He said the rights that were recognized and affirmed were those, quote, in existence when the Constitution Act came into effect. However, they should not be read so as to incorporate the specific manner in which the right was regulated before 1982. Thus, and I continue the quote, the nature of government regulations cannot be determinative of the content and scope of an existing Aboriginal right. End of quote. Aboriginal rights were constitutionally protected, and governments can infringe them only in limited circumstances, and if they wish to do so, governments bear a high burden of justification. I don't have a quote for that, but that's what was also contained in Sparrow. Now, the significance. Sparrow was the first case to delineate the scope of Aboriginal rights. Others had touched on it, like Guérin, but Sparrow addressed it more directly and more generally. 35(1) was to be interpreted in a purposive, liberal, and generous way. Now, you have to watch it with purposive, because purposive in the context of Aboriginal and treaty rights is not to be confused with purposive in terms of the interpretation of charter rights, which is in turn not to be confused with the purposive approach to statutory interpretation. I hope that's clear. But he said it's to be interpreted in a purposive, liberal, and generous way. And this continues to structure the analysis. As Robert Sharp has observed, Justices Dickson and Laforêt, and I quote from what Bob wrote, opted for a flexible interpretation that would allow evolution over time and require justification of all limitations whenever imposed. End of quote. Professor John Burroughs argues that in the framework for justifying infringement of Aboriginal rights, the court struck a compromise between two extremes. One, that Aboriginal rights continue to exist in their original form, as they did before European contact, notwithstanding that they had been regulated. That's one extreme. And the other extreme is that most rights had been extinguished as a result of their regulation. The court struck a middle course between these two. Justices Dickson and Laforêt wrote about the honour of the Crown and fiduciary duties. Now, both of these concepts have evolved through the jurisprudence, and fiduciary duties have taken on perhaps a more specific and narrow role, whereas the honour of the Crown has become really a foundational concept that's applied in a wide variety of circumstances. But there was an initial statement, which was an important one, as to the honour of the Crown and fiduciary duties in Sparrow. The Crown is to be held to, quote, a high standard of honourable dealing, end of quote. And this too is something which was has entered into the whole structure and the framing of Aboriginal rights. Sparrow departed from earlier decisions, notably in St. Catherine's Milling and Lumber Company and Calder, with respect to extinguishment of Aboriginal rights. Regulation is not the same as extinguishment. For the latter to have occurred, an intention to do so needed to be clear and plain. I mean, we overlook how significant that one determination was. It really provided the opportunity for rights which had been linked to the existence and operation of Indigenous societies to be given an ongoing and contemporary manifestation which would change over time, as opposed to being cut off or unduly limited by saying all that existed was that which was remaining after you applied the regulatory structure to harvesting and use of resources in particular. The enduring legacy, the scope of Aboriginal rights. Sparrow did not set out a framework to decide the existence and content of an Aboriginal right. That followed in Vanderpeet, 1996, several years later. However, the test in Vanderpeet built on the foundation set out by Justices Dickson and Laforêt, when the court stated that in Sparrow, the Musqueam fishing practices, quote, have always constituted an integral part of their distinctive culture, end of quote. As Chief Justice Lemaire wrote in Vanderpeet, Aboriginal rights protected in 35(1) are those integral to the distinctive culture of the Aboriginal group claiming the right, end of quote. Infringement, I'll just touch briefly on it. In Delgamu, the test for the infringement of rights set out in Sparrow was extended and applied to the infringement of Aboriginal title. Ongoing negotiations. Justices Dickson and Laforêt recognized that giving effect to Aboriginal rights is an ongoing process. They wrote that 35(1), quote, provides a solid constitutional base upon which subsequent negotiations can take place, end of quote. And I'll say a little bit about sovereignty. Justices Dickson and Laforêt stated, quote, "There was from the outset never any doubt that sovereignty and legislative power, and indeed the underlying title in such lands, vested in the Crown," end of quote. Thus, the Supreme Court situated Aboriginal and treaty rights, which I would consider a type of sovereignty, within the overarching sovereignty of the Canadian state. For Canada to exist, that sovereignty must exist. But it seems to me that one way of understanding the relationship of Indigenous peoples to Canada is that of a sovereignty within a sovereignty. In my reasons in Des Hôtels, where I was in the majority, and in Dickson versus Von Tut Gwichin, in which I was unfortunately in dissent, I deal with Indigenous groups as distinct political entities that, as of right, operate according to their own laws, customs, and practices. As a final point concerning Chief Justice Dickson, I would note that after he retired, he was considerably involved, deeply involved, in the establishment of the Royal Commission on Aboriginal Peoples. In closing, Brian Dickson was a person of goodwill. He was a jurist of insight and principle. He embodied fairness along with prudence. He sought to advance social justice with moderation. His jurisprudence was grounded in the historical context of Canada. He was unfailingly respectful of our traditions and institutions, and this was reinforced by his military service. His were liberal sentiments in a way that John Rawls was liberal. I think they were not quite contemporaries, but I'm not getting again into John Rawls, a bit late in the speech for that. But I see a great many parallels in the broad outlook of the two men. Brian Dickson was a wise man. As lawyers, jurists, and citizens, we continue to benefit from his wisdom through the foundational jurisprudence that he wrote. He exemplified all that a good judge should be. Thank you.
Thank you, Justice Rowe. We have a few minutes left, so I would now like to open it up to the audience for any questions. There are mics located in the aisles for you to use.
It may have been a soporific address that put you to sleep.
I hope it's okay to ask a question, even though I'm not a student anymore. I'm curious, you described Chief Justice Dickson's tendency to sort of pick a middle road between two extremes, and at the same time you spoke of his conceptual clarity.
Yes.
I wonder if it's challenging to get both of those things at the same time.
I must say, I don't think there's any incoherence or inconsistency between moderation and clear thinking. I mean, as a matter of fact, I think clear thinking is a good sign of moderation, and moderation is a good sign of clear thinking. I'm not saying that he just kind of cut it down the middle and said, let's all go home for lunch or something. I'm saying he thought it through, and it was a pretty good comment, among others from John Burroughs, that the court could have said, all of the limitations on Aboriginal rights, they're locked in. And that would have been very confining for the future. Similarly, to say that all of the limitations that are arisen from the operation of society, the regulation of harvesting and use of land and all the rest, those don't count. And then there would have been this enormous uncertainty as to what would have been, property rights or the rules of general application. And so neither of those was a good idea. And really, I think what he had in mind was neither of those was a just result, either for the citizens of Canada broadly or for Indigenous peoples. And so he did strike a sort of a middle ground, but it was a principled middle ground in which he said, those rights continue to exist and they will be manifested from time to time in a contemporary way. And that's pretty clear, but it's also moderate. And so I think it's just, there's something called good common sense too. I think he had a great deal of that. But it goes beyond common sense. It's about insight. It's about wisdom. What is a wise disposition? What is a just and durable foundation on which to address how we give effect to the Charter? So, that is how I'd reply to that question. Yeah.
Justice Rowe.
I was just wondering if you thought that Justice Dickson was like a unique product of his time, of that post-war period, of that kind of optimism about how things could be better, and whether you think that kind of, like the experience that he brought to his analysis is something that you'll see in the future, or is it very much like just because he was who he was when he was?
I mean, the immediate post-war period, 50s, 60s, 70s, obviously up to the early 80s, 85, 90 when he left the court, there was a sense of optimism, but it was optimism that was not based on the idea that things inevitably would go well. I mean, there was the Second World War, right? Things had gone terribly wrong, and enormous effort and sacrifice and commitment had to be made to put them on a sound footing for the future. So I think it was a thoughtful optimism, but I think it was tempered by experience and an understanding that there were certain guiding principles, certain values that were necessary to preserve a free and democratic society, and that the Charter was really an exercise in doing that, in preserving and advancing Canada as a free and democratic society. And then another part of the Constitution Act 1982, which was outside the Charter, the protection of Aboriginal treaty rights, that was part of a something that we had to do as a country to become our better selves, because it was a matter of great failure, and it needed to be addressed, and it needed to be addressed in a principled and ongoing and serious way. So he wasn't just Pollyannish. He was. I think he was optimistic, but he was optimistic with a lot of realism. Yeah.
My question is, you spoke about Chief Justice Dickson's jurisprudence and its influence across the world. So I was wondering if you could speak a little bit more about Canadian jurisprudence and law and its influence in general in the global sphere and international law, and maybe how that might create a responsibility, and how do we respond to like more unique challenges as law students, lawyers, and courts in international law that we haven't seen before, such as climate change and the rights of Indigenous people.
Right. I think it's important to bear in mind the distinction between international law and comparative law. Okay? International law, broadly speaking, is the law of nations. Now, some of it does relate to individuals, but it's mainly how states relate to one another. It's governed by conventions, conventional international law, then there's customary international law. And Canada has had a proud history of contributing to the development of international law notably in the immediate post-war period. The Universal Declaration of Human Rights, 1948, I think, something like that, was written largely by a Canadian. Maybe we should be a little more active in those fora. But comparative law is the law of other countries, domestic law of other countries. And so when I spoke about the influence of the jurisprudence and the, for example, the Oakes test, and I referred to, I guess, the UK, Hong Kong, Australia, South Africa, and Israel. That's comparative law rather than an international law. And there is, I think, a more direct impact through comparative law than there is through international law. And while we have to make our own decisions, of course, we can learn from comparative law. And I'd give you a very good example of a body of comparative law, which I think is very helpful in informing charter jurisprudence, decisions relating to the European Convention on Human Rights. Roughly 1952, I think it was adopted. If you read the European Convention on Human Rights and you read the Charter, they look very much alike. They're not identical, but they look very much alike. And of course, one of the things that was taken into account in 1981 and 1982, when the Charter was put together, was looking to the European Convention on Human Rights, because it was seen as a very considerable accomplishment. What we have in Europe is a very rich jurisprudence, which has been developed at the national level and then through the European Court of Human Rights, which has interpreted and given effect, given application to the content of the convention. And because it so closely parallels the content of the Charter, and because we're dealing with countries of a broadly similar character, right? Western industrialized countries, you can look to the comparative situation in Europe and say, well, how have they approached things? Is there something there for us to learn? And I think they are looking to us as well. I didn't refer to the European Court, but I think, well, I do know that they have regard to our decision. So the jurisprudence of the Supreme Court, particularly that of Justice Dickson and others, its contribution is more directly in the comparative law area rather than international law. Yeah.
Oh, there's so many people. I guess my question is, as a law student, something I've really struggled with is maybe situating Section 7 of the Charter versus the Oakes precedent that we've established, and you talked about Justice Dickson, sort of where it was foundationally at in the 80s when he sort of created and walked through Oakes, and versus where we are now with Section 7 jurisprudence of sort of, when is Oakes ever really applicable? I kind of wonder to myself, like, is the jurisprudence around Section 7 still consistent with Oakes? Is this idea that we're talking about like individualized rights in Section 7 principles of fundamental justice versus this sort of generalized populist analysis that takes place in Section 1, is that what the intent was when we looked at Section 1, or is this evolution in the jurisprudence like Michaud kind of really changed that?
I think one of the things you have to take into account is that while most charter rights do not contain internal limits, Section 7 does. It talks about life, liberty, and the limitation of this in accordance with the principles of fundamental justice. Okay. Now, there's an analysis which hinges on the principles of fundamental justice, and that is the framework for the justification of the limitations in Section 7, and arguably extending out through 8 through 14, although that's a complex question. How much the internal limits of 7 are manifested in 8 to 14, or if there's an infringement of 11D, do you go to Section 1, etc. I've spilled some ink on that one myself. But what I would say is that the internal limits and the analysis that arises from that in Section 7 has somewhat displaced the Section 1 analysis vis-a-vis Section 7. And I think that's valid, but Section 1 doesn't disappear. And there may be factors that are given a certain effect under Section 1 that aren't given the same effect under the principles of fundamental justice. So I think it's an area where maybe the Supreme Court of Canada should clarify the methodology a little bit. I mean, I'm not saying that it's incoherent. I'm just saying that I don't think we've laid out a sufficiently clear roadmap. And one of the responsibilities of the Supreme Court of Canada, perhaps like the prime directive, is give clear guidance, right? Give clear guidance because we can speak authoritatively to the legal community so that lawyers can advise clients, so that lawyers can plead before judges, trial judges know what to do, courts of appeal, et cetera, to provide the guidance that is needed for everyone else in the legal system to do their job. And so, Section 7 and Section 1, the internal limitations in Section 7 and the justificatory analysis under Section 1 needs a degree of clarity. Yeah.
Thank you.
We have reached the end of our available time. Thank you everyone for your questions and your interest in today's lecture. If you haven't had a chance to enter the door prize, please feel free to do so. On behalf of the editorial board of the Saskatchewan Law Review, our student body and faculty, thank you, Justice Rowe, for bringing this lecture to us today. We appreciate your insight you have provided on the work of Chief Justice Dickson.
Thank you.
Thank you.